Lesson: Implications of Schrems II and cross-border data transfers. The Schrems II judgment, delivered by the Court of Justice of the European Union in July 2020, has had profound implications for cross-border data transfers between the European Union and third countries, notably the United States. This landmark decision invalidated the Privacy Shield framework, a crucial mechanism that enabled transatlantic data flows due to concerns over U.S. surveillance practices and the lack of adequate protection for EU citizens' data. As a result, organizations that engage in cross-border data transfers have been compelled to reassess their compliance strategies to ensure conformity with the General Data Protection Regulation and to protect the personal data of EU residents adequately. The Schrems II ruling necessitates that organizations implement more stringent measures to ensure the protection of personal data transferred outside the EU. One actionable insight from this decision is the need for organizations to conduct thorough assessments of the legal frameworks in third countries where data is being transferred. This involves evaluating whether these countries provide a level of data protection that is essentially equivalent to that guaranteed within the EU. Such assessments are crucial in identifying potential risks associated with data transfers and in determining the suitability of supplementary measures to mitigate these risks. A practical tool that organizations can utilize in this context is the European Data Protection Board recommendations on supplementary measures. These recommendations provide a framework for assessing third-country legal protections and implementing additional safeguards where necessary. For instance, organizations may consider employing technical measures such as encryption and pseudonymization to protect data during transfer. Encryption ensures that data is unreadable to unauthorized parties, whereas pseudonymization masks personal identifiers, reducing the risk of data breaches. Furthermore, the Schrems II judgment emphasizes the importance of data transfer impact assessments. TIAs are akin to data protection impact assessments and serve to evaluate the potential risks associated with transferring personal data to third countries. These assessments should be conducted regularly and whenever there is a change in the legal or operational environment of the third country. By identifying and addressing risks proactively, organizations can enhance their compliance posture and protect data subjects' rights effectively. Contractual mechanisms, such as standard contractual clauses, remain a viable option for facilitating cross-border data transfers post-Schrems II. However, organizations must recognize that the use of SCCs alone may not be sufficient to ensure GDPR compliance. The CJEU ruling mandates that organizations using SCCs must verify on a case-by-case basis whether the destination country provides adequate data protection. If the protection is deemed inadequate, organizations must implement supplementary measures to address the deficiencies. An effective framework for implementing SCCs involves a step-by-step approach to assess and enhance data protection measures. First, organizations should conduct a comprehensive analysis of the data transfer scenario, identifying all parties involved and the nature of the data being transferred. This includes understanding the data processing activities and the potential risks involved. Next, organizations should evaluate the legal framework of the destination country, considering factors such as government surveillance practices and the availability of legal remedies for data subjects. Once the analysis is complete, organizations should determine appropriate supplementary measures to safeguard the data. These measures may include technical solutions, such as end-to-end encryption, and organizational safeguards, such as strict access controls and regular audits. By adopting a structured approach to implementing SCCs, organizations can demonstrate their commitment to data protection and compliance with Schrems II requirements. In addition to SCCs, binding corporate rules offer an alternative mechanism for cross-border data transfers within multinational corporations. BCRs are internal policies that ensure data protection across corporate entities, regardless of their geographical location. To implement BCRs effectively, organizations must develop a comprehensive data protection framework that adheres to GDPR principles and is approved by the relevant data protection authorities. This involves establishing clear policies and procedures for data processing, training employees on data protection practices, and conducting regular audits to ensure compliance. A case study that illustrates the practical application of BCRs is that of a multinational technology company that implemented BCRs to facilitate data transfers between its EU and US operations. By developing a robust data protection framework and obtaining approval from EU data protection authorities, the company was able to streamline its data transfer processes while ensuring compliance with GDPR requirements. This approach not only enhanced the company's compliance posture, but also strengthened its reputation as a privacy-conscious organization. The Schrems II ruling has also highlighted the need for transparency and accountability in cross-border data transfers. Organizations must be transparent with data subjects about the transfer of their personal data to third countries and the measures in place to protect their data. This involves updating privacy notices to include information about data transfers, the legal basis for such transfers, and the rights of data subjects. Additionally, organizations should establish clear processes for handling data subject requests related to cross-border data transfers, such as requests for access, rectification, or erasure of their data. To enhance accountability, organizations should maintain detailed records of their data transfer activities, including the legal basis for each transfer and the supplementary measures implemented. These records should be readily available for inspection by data protection authorities and should be updated regularly to reflect any changes in the data transfer scenario. By maintaining comprehensive records, organizations can demonstrate their commitment to transparency and accountability, thereby building trust with data subjects and regulatory authorities. Statistics underscore the importance of robust data protection measures in cross-border data transfers. According to a study conducted by the International Association of Privacy Professionals, 60% of organizations reported increased scrutiny of their data transfer practices following the Schrems II ruling. This heightened scrutiny underscores the need for organizations to adopt a proactive approach to data protection and compliance. In conclusion, the implications of the Schrems II ruling for cross-border data transfers are profound and far-reaching. Organizations must implement actionable insights and practical tools to navigate the complexities of this legal landscape effectively. By conducting thorough assessments of third-country legal frameworks, leveraging contractual mechanisms such as SCCs and BCRs, and enhancing transparency and accountability, organizations can ensure compliance with GDPR requirements and protect the personal data of EU residents. The integration of frameworks and tools, such as the EDPB recommendations and TIAs, provides a comprehensive approach to addressing real-world challenges, enabling organizations to enhance their proficiency in cross-border data transfers and build trust with stakeholders.